Hello, this is Matt on the Moon Lambo channel. I've got a quick legal update for you regarding the SEC versus Ripple case, and according to attorney John Deaton, it seems that the judge, in a recent action that's being taken, one of the effects of this would be the limiting of the losing side's options. So post the case, whether the SEC loses or Ripple loses, assuming there's full adjudication here, what's being done here, in part, according to attorney John Deaton, would limit any sort of response. And I'll explain what is meant by that as we go further. Also have a number of comments from attorney Jeremy Hogan, who runs the very popular YouTube channel Legal Briefs, which I'll assume that 100% of you are very familiar with at this point. And if not, what is functionally your problem? Go subscribe there. But before going further, I want to be clear, I don't have a legal or financial background of any kind. I am not offering legal or financial advice, and you definitely should not buy or sell anything because of anything that I say or write. I'm just an enthusiast who enjoys making YouTube videos about crypto-related topics, but just as a hobby and just for fun, damn it. And if you don't like it, well, you can just get out. And so here is the recent legal filing. It's from literally just yesterday. It's from Judge Sarah Netburn. And it's on your screen. I don't feel the need to read it, but it's right there if you want to just pause right here and actually read it. Other than that, it's so short. It's a number of sentences. But I'm just going to go ahead and just cover what Jeremy Hogan had to say with it because he already sums it up. So I didn't feel it necessary to read it and then have him sum it up effectively anyway. But here's what Jeremy Hogan wrote. The Court of Appeals, which the Ripple vs. SEC court is under, just issued an opinion which changes the law a bit for what is protected by the deliberative process privilege, or DPP for short. So let me just pause you to give you a reminder because you may be familiar with this term and there's so much legal jargon. And, if you're like me, as most of you are, and you don't have any sort of legal background, it's hard to keep all of this stuff straight. Well, I think this will remind you right here. Here's one of many headlines on this topic. This article from CoinGate, September 28th, 2021. The headline reads as follows. XRP Lawsuit. SEC uses deliberative process privilege, DPP, yet again to avoid discovery. And so you may recall that they've been using their quote-unquote privilege to claim that all of our internal documents, this communication, it's privileged. It's got to be super duper top level mega secret. Ripple can't have it. We can't let this stuff get out in the public because it's privileged government information. And as a result, they've made this claim under DPP I think we would argue, it is being argued, and I think that we would agree this is the case in all likelihood with virtual 100% certainty that these claims are being made that they're bogus, but it's to prevent highly relevant information from being discoverable so that you couldn't actually use it as evidence in the course pertaining specifically to Ripple and XRP and Bitcoin and Ethereum and a number of other things in the way that the SEC approached this. Which really always goes back to this idea of Ripple's fair notice defense. This idea that obviously Ripple being fully transparent, operating as a business for close to a decade, if what they were doing was wrong, the SEC would have had to have made it clear that what they were doing was wrong. A reasonable market participant would not know that what Ripple was doing was wrong. That's the fair notice defense in a nutshell. And so if there's an indication that the SEC wasn't even clear about how to classify XRP specifically, and there are other considerations as well, if that's the case, then this case is over. Ripple just wins because you can't do that. And so that's what we're talking about here with the deliberative process privilege. And so anyway, Jeremy continues though. So referencing this law which has changed, he says, since the law has changed, the parties are being given a chance to rebrief per the new law. And what they're talking about, what's being discussed here, here's an article from Bloomberg titled, EPA Wins Appeal Over Release of Pesticide Policy Making Records. And so my understanding is basically as a result of this, which was dated November 29th this year, it's basically effectively changed law and set new precedent. And so this is what's being referenced. Jeremy continues now. DPP is important as to whether the SEC has to provide certain internal communications about digital assets and whether they are securities. Attorney Filan here, at Filan Law, James Filan, told me this was coming, and I've read the opinion, and the law change slightly favors the SEC. So this is actually a good thing for the SEC, at least potentially, right? And then he wrote, let's see what the briefs say. And then he has a separate explanation in football terms. So here he wrote, explain it in football terms. The parties lined up for the extra point on the 2-yard line, but the NFL Rules Committee just changed the rule to make Ripple line up on the 5-yard line. The teams each have until next week to line up according to the new rule. And then here's another explanation. Explain it to me like I'm a 5-year-old. You gotta love Hogan. So here's the explanation, as if you were a 5-year-old. Listen, sweetie, sometimes Dad changes your bedtime, and there's nothing you can do about it, so I'm going to give you 5 minutes to get your butt in bed, or I'm throwing your teddy bear away. Good night, I love you. I love his sense of humor. Mine is not terribly different, so I like that. But anyway, so in terms of the broader implications of this, I'm not trying to overstate it or anything, but you'll see as I get to John Deaton's comments just a little bit later in this video why I started off the way that I did. And as you'll see, according to John Deaton, it seems as though this is something that could affect how the loser can respond to the case. Now, somebody who just calls themselves Bulgaria at XRP4Winners on Twitter wrote to Jeremy and said, so before you kiss us all goodnight, does the rule change benefit one side or the other more, or is it just meaningless court jargon for it's just a change in wording but means the same? Kind regards, Paul. And Jeremy responded and wrote, I read the opinion and it helps the SEC a bit. I will wait to see what the briefs say, but I'm still curious how the SEC could argue they were even deliberating to begin with. And so what's he talking about there? Here, let me pull this up. I should have had this lined up differently, but I did pull this up because I knew exactly what he was talking about. Here's a tweet from Jeremy Hogan, September 28th this year, 2021. And he wrote, clever. Ripple argues that the deliberative process privilege does not apply to any of the SEC's documents it does not want Ripple to obtain because the SEC itself has never deliberated about policy, re. digital assets. E.g., Hinman was only deliberating for himself, not the SEC. Now, that is a clever and brilliant point. So think about what he's saying right here. I'm sure you're well aware that former SEC director, Billy Hinman, who gave that speech back in June of 2018, which gave Ethereum a free pass, he claimed in a one-liner, this is just my personal opinion, but of course we know it was presented in such a way that the markets globally would take it as official decree from the SEC. We also know that then SEC Chair Jay Clayton, asshat, also had a touch on this and impacted what was spoken by Hinman. But of course it was just Hinman's opinion, right? So we don't buy that, but that's the claim that the SEC is making. The SEC has never deliberated publicly about digital assets. There's just been a string of personal opinions, right? And so Ripple recognized that and says, wait a minute, you're arguing that the DPP, deliberative process privilege, but SEC, you're saying you haven't deliberated about anything. So how can this be? How can DPP apply to anything? Which is to me, a hilariously awesome move on Ripple's legal team's part. I talked about it back when it happened, and I just got a kick out of it, and I still do, actually. Next, I think I had another one from Hogan here. Make sure I get my spot back where I was. Yeah, here we go. This is where I wanted. Okay. Somebody else wrote to Jeremy Hogan, I'm confused. How does an opinion change a law? Is it common for an opinion to change a law in the middle of a case that is directly affected by this change? Simpleton here just trying to comprehend. Thanks. And Jeremy did respond and wrote the following. It's happened to me before a couple times. In fact, Florida just changed its summary judgment standard and messed up my hearing this week. We have to rebrief as well. And so there you go. Broader legal implications as a result of a case unrelated specifically to what's happening in the SEC versus Ripple, but ramifications nonetheless. And then there is this from attorney John Deaton. He wrote, while Judge Netburn was what's the emoji? How do I read it? So it's a little handwriting emoji. Was writing. That's how I'm supposed to read. Sometimes Sometimes when I'm reading these things, and I did obviously read this before recording the video, I read it and it's like it flows properly in my brain. But then I see the same emoji where when I'm recording this video for you listening, I need to turn the emoji into a word, and my brain just like something like utterly breaks inside, and then I can no longer communicate, which is what just happened here. Anyway, while Judge Netburn was writing her decision, there we go, that's the one, or possibly after it was already written but not yet published, a decision on the deliberative process privilege was issued by the Second Circuit Court of Appeals. Judge Netburn ordered both sides to provide a 3-page supplemental brief by December 8th. I haven't had time to read the Second Circuit's November 29th decision, so I can't comment whether or not it will have an impact one way or the other, whether it's good or bad for either side. If she didn't do this, it's likely the losing side on her decision would raise it as an issue. Smart. And so John Deaton's basically saying, regardless of the specifics, this is going to eliminate a potential route to complain that the court finding ultimately was not just. So John Deaton's saying that Judge Netburn is trying to prevent such a scenario. And so that is pretty well where we're at. Interesting stuff here. So again, the degree to which it's better for the SEC versus Ripple, I don't have any additional information at this time, but I'm going to continue to track this and will continue to report court-related developments as they occur, but that's all I got for you for the moment. End hot jam. I am not a financial advisor. You should not buy or sell anything because of anything that I say or write. That would be a very, very, very bad idea. Until next time, to the moon, Lambo.